topic of this video is looking at sort of the different ways of thinking about law and how to interpret it, and how that might influence the way Supreme Court judges make the decisions they do and issue the opinions that they do. So, the two major ways to look at law, and again, this is a major issue of contention between the political parties today, are those that are in support of what we call judicial restraint, and those are in support of what we call judicial activism. Again, these are different ways to interpret the law, and these are ways in which the Supreme Court might go about its decision-making process. So people that support judicial restraint, more often than not, tend to be conservatives, right? They argue, like as the name implies, that the judicial branch should most definitely be the least active of the three branches. And that's because these people aren't elected, that they should be very selective and particular when they get involved in a dispute, because at the end of the day, nobody's voting for them and people are voting for the other branches. So the judicial branch should restrain itself and really not take a super active role in sort of like the governing process, right? Those that favor judicial activism tend to be more liberal, and they tend to support a different philosophy. Because the judges aren't elected, the judges should get more involved, especially them having a unique responsibility to help out minorities. Because the other branches that have to play to the majority, because they have to worry about getting reelected, might not be able to do what's in the best interest of minority groups. Judicial activists argue the judicial branch should play an active role in society, especially in protecting the rights of minorities, because they are insulated from public opinion and they don't have to worry about doing what's popular. So again, they're both arguing something about the branch not getting elected. Judicial restraint supporters are arguing that means they should be involved less. Judicial activism supporters are arguing that means they should be involved more. The fundamental difference they have between the two sides, though, is, again, how to make decisions. So people that support judicial restraint argue that when judges are making legal decisions, the number one thing they should take into consideration are the original words the founding fathers found in the Constitution. That philosophy is known as originalism, that there is no room for opinion, there's no room for your own bias, there's no room for your own interpretation. It's all about the words that are on the page in the Constitution, and that's how judges should be guiding their decision-making process, right? People that support judicial restraint also support something called stare decisis, which is like high respect for precedent. Again, how the Supreme Court has decided issues in the past should go a long way in determining how the Supreme Court decides issues in the current state, right? So that's how judicial restraint people would argue that justices should make their decisions. What did the founding fathers write in the Constitution? Your job as a judge is to defend the Constitution, not to like make up stuff that you think should be in the Constitution. Judicial activists would argue that that's a ridiculous way to look at society in 2024. How are you going to use a document that was written in 1787 to determine legal disputes in 2024? That's the art of being a judge, is to take the words of the founding fathers and see if you can't put a modern interpretation on them, to adapt them to modern times. So a great example to show you the dispute between the two sides is the issue of abortion. People that support judicial restraint, conservatives, would make the legal argument that abortion is not mentioned anywhere in the Constitution. Therefore, there is no way that the Supreme Court judges defending the Constitution could argue that there is a federal right to protect it, right? The federal government can't protect the right to abortion because there's nothing in the Constitution that says they can, right? Whereas somebody that supports, so leave it up to the states would be their argument. It can't be something the federal government protects because it's not in the Constitution. It has to therefore be a state-by-state decision. People that support judicial activism would argue that's absurd, right? Abortion wasn't an issue that was even on the radar screens of politicians in 1787. Of course, it's not mentioned in the Constitution. So they would argue that a judge has to do a little bit more work to interpret how the founding fathers would think about abortion today. So like, for example, several early amendments the founders wrote dealt with the issue of privacy. So it's clear that the founding fathers cared about privacy. Like making a conclusion, abortion is a private matter with your own body. Therefore, the federal government should protect it, right? So it's like kind of connecting the dots where judicial restraint is much more direct. So again, they very much disagree on how to interpret like the law. Judicial restraint, it's just about the words on the page. Judicial activism, you could take more interpretation into consideration, and that's the job of the judge, is kind of put a modern spin on an older document. The other major thing that people that support judicial activism believe in is something called comparativism. This is the idea that when deciding like how the Supreme Court's going to rule on really controversial issues, we should take into consideration how other countries handle that issue. Whereas that's called comparativism, where somebody that supports judicial restraint would say, that's absurd. Why do I care what another country cares about that issue? All I care is about what the Constitution like says about that issue. Like, for example, somebody that supports judicial activism might argue that most other countries, similar to the United States, have already outlined the juvenile death penalty. We, as the Supreme Court, should take that into consideration when making a decision about whether under 18-year-olds could be sentenced to death. Is that it's less to do about our Constitution, but more about like how do we fit in with the rest of the world. People that support judicial restraint would not support that way of thinking. They wouldn't care about what other countries do with that issue. It's really more importantly what the Constitution says. So again, these are the two different legal philosophies. Again, judicial restraint is typically supported by conservative justices and judicial activism by more liberal justices.